For those of us on this side, our job is not to theoretically evaluate this or that legal doctrine, or to review Judge Gorsuch's record in a vacuum. Our job is to determine whether Judge Gorsuch is a reasonable mainstream conservative, or is he not. Our job is to assess how this nominee's decisions will impact the American people, and whether he will protect the legal and constitutional rights of all Americans, not just the wealthy and the powerful. We hold these hearings not because court precedent and stare decisis are something average Americans worry about. We hold these hearings because the United States Supreme Court has the final word on hundreds of issues that impact our daily lives. The Supreme Court has the final say on whether a woman will continue to have control over her own body, or whether decisions about her health care will be determined by politicians and the government. It decides whether billionaires and large corporations will be able to spend unlimited sums of money to buy elections, and whether states and localities will be able to pass laws and make it harder for poor people, people of color, seniors, and younger people to vote. It is the Supreme Court that will have final word on whether corporations will be able to pollute our air and water with impunity, or whether the NRA and other extreme organizations will be able to block common sense gun regulations, including those that keep military-style assault weapons off our streets. And it is the Supreme Court that will have the ultimate say on whether employers will be held accountable for discriminating against workers or failing to protect workers when they're harmed or killed on the job. Last year, Judge Gorsuch sat on a case that involved a truck driver who was stranded in the freezing cold for several hours after his trailer's brakes froze. He had no heat. In fact, it was so cold that the driver was having trouble breathing. His torso was numb and he could not feel his feet. Despite this, his employer directed him to wait for a repairman or else drive both the truck and the trailer. When no one came, the driver unhitched the trailer to search for assistance, because driving with frozen brakes with a fully loaded trailer would have been too dangerous. A week later, he was fired. After hearing the case, the administrative law judge ruled that firing the driver was a violation of the health and safety law intended to protect workers. The United States Department of Labor's Administrative Review Board and the 10th Circuit agreed. Judge Gorsuch dissented and sided with the company. In another case, Judge Gorsuch wrote a separate opinion, this time to challenge a long-standing legal doctrine that allows agencies to write regulations necessary to effectively implement the laws that Congress passes and the President signs. It's called the Chevron Doctrine. This legal doctrine has been fundamental to how our government addresses real-world challenges in our country and has been in place for decades. If overturned, as Judge Gorsuch has advocated, legislating rules are very difficult. The debate over Roe v. Wade and the right to privacy, ladies and gentlemen, is not theoretical. In 1973, the court recognized a woman's fundamental and constitutional right to privacy. That right guarantees her access to reproductive health care. In fact, the Supreme Court has repeatedly upheld Roe's core finding, making it settled law for the last 44 years. Judge Gorsuch has also stated that he believes judges should look to the original public meaning of the Constitution when they decide what a provision of the Constitution means. This is personal, But I find this originalist judicial philosophy to be really troubling. In essence, it means that judges and courts should evaluate our constitutional rights and privileges as they were understood in 1789. However, to do so would not only ignore the intent of the framers, that the Constitution would be a framework on which to build, but it severely limits the genius of what our Constitution upholds.